I'm going to start recording. Okay, so I'll bring people in. Hi there, everyone. We are just waiting for everyone to join. It's about 1 o'clock. We'll give everyone a few minutes to get going. But thanks, everyone, for joining us today. We have Rob Brunet with us. He is a patent agent and the principal at Brunet and Co. I'll let him give us a bit of background on who he is and a little bit more about patents in a few minutes. But before we get going, and while we're waiting for people to join us, why don't you pop into the chat? If you're a guest here and you're not part of the accelerator, then in the chat, just send me a quick message and let me know what your name is and your connection to Western. Are you student, staff, or faculty? What is it? And that way I know a little bit about who's in the room with us. So for those of you who don't know, so this is currently a workshop that we run with the Western Accelerator. So everyone who is part of the accelerator is part of our presentation today. They will be asking some questions about their specific IP, and I'll unmute you guys when the right time permits. Yeah, this is a workshop that we run for the Western Accelerator. For those of you who aren't familiar with the accelerator is it is a physical space and an opportunity for entrepreneurs at Western to accelerate their business. We do a lot of education, and we provide funding for entrepreneurs who want to launch their own business. And you can find more about that at uwo.ca/accelerator. Now, I think we have most people who are going to join us now. We currently have 14 people. Make that 15 people on our call right now. So that is a great turnout. Rob, do you want to go ahead and maybe share a little bit about who you are, and we'll get the presentation started.
Sure. Thanks for the introduction, Jeremy. I expect that a lot of the increased participation is because everybody is homebound with COVID-19 and looking for some social interaction. We've been out of the office for about 2 weeks, so it's kind of a new working environment for everybody. I've been burning up the Zoom channel since that time, so great to be here on this virtual medium. So background about me, I'm a patent agent, founded the firm Brunet & Co. in 2006. My background is in chemical engineering. I have a bachelor's and master's degree in Chem Eng from Western. And I initially worked in research and development for Trojan Technologies, a manufacturer of ultraviolet disinfection equipment for treating drinking water and wastewater. Worked there in R&D and later in management roles until leaving in 2001. So I had about 10 years of experience in industry before getting into the patent business. And since that time, I've worked with companies ranging from startups to multinationals. About 40% of our business is international, 60% of it is domestic in the southwestern Ontario area. So we focus on chemistry, life sciences, medical devices, but also reflecting our local economy, manufacturing, so things like agricultural equipment, automotive, those sorts of things. So what I was hoping to do today was give you a bit of an overview of intellectual property and I guess specifically the patent process. And then after we've done that overview, what's worked well in the past is we just kind of get into a Q&A. So I wanted to give everybody a chance to give a little bit of a background on their business and why they think IP might be important, and then we'll kind of go into specific case examples and answer your questions and have kind of a workshop format. And I think go ahead.
Yeah, sorry, Rob, I'll interrupt for a quick second. Given that this is a workshop for the Western Accelerator teams, we're going to take questions from the Accelerator teams first, and then if anyone else has questions after that, we'll be taking those questions as well too.
Okay, great. So without further preamble, I'll just launch a brief presentation to give you some background. Can I share my screen, Jeremy?
Yeah, you should have co-host ability there.
Okay. Let's just see now. Give me a moment to get my technology oriented here. Zoom. And share the screen. So are you able to see?
Yep.
Does it say types of intellectual property?
That's right.
There we go. All right. So what I'm seeing is something that doesn't look like the full screen view. Is it full screen on your side?
Yeah, it's full screen on my side.
Okay, great.
Yep.
All right. So just to begin and give everybody a bit of an overview, there's really four main types of intellectual property that we'll be concerned about, and most companies are concerned about. The first would be patent, second is trademark, third is industrial design, and the fourth is a copyright. A lot of times people conflate these concepts, so I want to be clear about what they're about. So a patent is about how something works, so it's functional. A trademark relates to how something is known in commerce, so this is more like words, names, logos. And industrial design is how something looks, so basically visual features of an object that may be distinctive. And a copyright literally means the right to make copies. So this would apply to typically artistic works, but also applies to software, traditional software, and literary works. So when I say traditional software, these days, software as a service means that typically people are downloading some kind of application, but the actual software itself is not being hosted on their machine. So we get into kind of some hybrid situations where copyright is less applicable than it used to be in many cases. So the features of a trademark is, first of all, available under common law. So the protection that you get from a trademark is automatic. As soon as you start using a name and marking it with a TM symbol, you can claim some sort of trademark protection rights. And that comes without registering the trademark. However, when you rely on common law protection, it's typically limited. So it's limited to your geographic trading area where people would know your business. So the way that you really enhance that right and make it nationally applicable is by registering the trademark. And once you've registered it, you get to use that R in a circle symbol behind the name. So that's the distinction between registered trademarks and common law marks, is the type of symbol that you see after the mark. Another interesting feature is that the lifetime of a trademark is unlimited. Even, for example, the Bayer Cross, I think, is more than 100 years old. There are some very old marks. Smith & Wesson is another very old mark, more than 100 years old. So some of these things, get stronger and stronger as time goes on if the brand continues to be used. The lifetime is unlimited, so the registration grants permission to use the mark as well as exclude others from using the mark. So that's another key feature that is kind of unique about a trademark and isn't the same in other forms of intellectual property protection. Here, the registration of a mark is actually a form of permission. So it's actually a certification that a search has been done and that you have the exclusive rights to that name. Now, a trademark is limited to certain claimed categories of goods and services. So I could have the mark, let's take an example, lightning, okay? Lightning is a mark that appears on a variety of different types of products, or Skyview is another one I've looked at. Skyview is, I think there's a Skyview pools in London. There's other types of Skyview. There's a Skyview restaurant. There's all sorts of different businesses that have Skyview as their trademark. But because the trademark protection that you get is limited to a claimed category of goods or services, multiple marks can exist for the same word, but in different categories of use. So that's something that's important to know about trademarks. And finally, the registration scope for trademarks has expanded a lot recently. So our Trademarks Act was amended in July of last year. And so we can now seek trademark protection on moving GIFs. We can seek trademark protection for holograms, sounds, smells, all kinds of interesting different things, and 3D shapes, if your shape is distinctive and associated with your goods, and that's kind of an evolving area of the law. The main type of intellectual property right that people are mostly concerned about when we have these presentations is patents. So I always think it's useful to begin with the foundation. What is a patent? So a patent is a bargain with the state, put simply. It's a time-limited monopoly in exchange for your disclosure. And the rationale behind that was to give people who had patents, rather than keeping their invention secret and not telling others how it worked, by disclosing the invention, we allow others to improve upon it. And so the idea of the bargain is that rather than you keeping your invention secret, I'm going to give you, the state is going to give you a 20-year monopoly in order to benefit publicly from that disclosure. So they have national scope. A patent is only good in the country in which you've applied and granted the patent, and it expires 20 years after filing. So I think a really important concept around patents is that they convert something that is an intangible idea into a form of property. So by doing that, by converting an idea into property, now we can do things with it. We can sell it, we can assign it to other people, we can license it, we can do all sorts of things with that piece of property that we can't do with just a basic idea. And I think that's kind of a critical thing to keep in mind. And then differently from a trademark, a monopoly is granted that excludes others from doing what is claimed. So there's no permission, there's no tacit approval of your ability to practice your patented invention. All that you get with the patent right is the exclusion of others from the monopoly that you've claimed. So that's an important distinction to keep in mind. It's not permission to do anything. So what I think is important to take away from this slide is that although people normally think of a patent as protection from others, in other words, they're getting this patent because they have the greatest idea in the world and it's going to be copied, really, patent has other purposes. So in the early stage of your business, really what the patent is an organizing principle, because you'll need to bring together people from different backgrounds to help you get your product and your company off the ground. So for example, you may need a manufacturing partner, you may need a marketing partner, you're going to need financial partners. And in the early stages, what tends to happen is, they say, you've told everybody how your invention works, and the manufacturing partner, for example, says, well, why do we need logins? We've already figured out everything that's important about this. What do we need him or her for? Let's just go ahead and make this ourselves. And so in the early going, the partners that you bring together have a tendency to veer off in different directions. And the patent provides an organizing principle that keeps everybody on the same page going forward, because you as the patent holder, really have the rights to prevent these other people from going off script. Later, if the invention is very successful, then it becomes about protection from competitors. But in the early going, it's really about protection from friends. And then, some of the main reasons as well that you may be interested in a patent is to attract funding. That's probably the number one reason. It's always a critical item on due diligence, and it's a question you're going to be asked. It provides some marketing cachet, and being able to say that your thing is patent pending. Oftentimes I've seen getting listed in a big box store, for example. You can't get your product into the store in many cases unless you've got some kind of patent right, because as soon as you go and try to take your patent into that retailer, they're trying to find a lower cost of a lower source of supply, lower cost source of supply for that product. So really the patent is about building future value. I'm just going to quickly skip over this and just go to bullet point 3. For something to be patentable, it has to be new, useful, and non-obvious. So those are the 3 things that we talk about. Useful is fairly straightforward. It means it's not some abstract theorem. But new means it's never been done before by anyone, anywhere, in any language, in any country, at any time. And non-obvious is a little harder to assess. So non-obvious typically means that a combination of documents, when put together, allegedly disclose all the features of your invention. And what we have to prove is that that combination of documents, there's something missing, some important piece that wasn't recognized by the people who went before. And that's usually the hardest part for you to assess as an individual, and why you need help from people like me, is to kind of figure out what is our answer to the obviousness allegation. And then the final bullet point there, it's important to keep in mind that there's certain categories of things that are not patent eligible. And in general, things like methods of medical treatment. You can't patent a method of surgery, for example, in Canada or anywhere in the world, except for the United States, where you can. But the principle behind that is that a doctor should not be prevented from exercising their life-saving skill by reason of a patent blocking them. So methods of medical treatment are not permitted. And similarly, professional skill in general is not patent eligible. So the classic case is Lawson versus the Commissioner of Patents, where an architect had a certain wine glass shaped lot and was not permitted to patent his wine glass shaped lot for subdividing homes, because that was exercise of professional skill, and he couldn't prevent others from similarly utilizing their skill. So I'm just going to skip over that because it'll probably come up in our discussion later today in more specific examples, particularly around software. So generally the steps in the process, we conduct a prior art search to look for other documents that would disclose either all of the features, thereby rendering it not new, or a combination of documents discloses all of the features, thereby rendering it obvious. That's typically what we're looking for. Now, you don't need me to do a search, and you should be doing your own searches on Google Patents. So the URL is google.com/patents. And then the official websites of the various patent offices, the US Patent Office, the Canadian Patent Office, and the European Patent Office. So those links there will take you to the most relevant places to search. The next stage after that is to prepare an application. And so what we need in order to do that is from the inventors, we look for kind of three things. So what are the differences between what you've done and the prior art? What is your disclosure? In other words, some drawings and some description of the important features. And finally, experimental data, if any. And that is typically the thing that gets us over the obviousness allegation, is we had to solve some problem that wasn't known how to solve before. It took trial and error. We did some experiments, and that's how we solved it. And that typically is the piece that's needed to help get over the obviousness allegation. And then when we file an application, we typically file it first as a provisional application in the US. The provisional application is just a filing tool. It's no different in scope than any other application. And it buys us a year to add disclosure if we have any. And then once we add that, let's say additional experimental data or additional disclosure, we file national applications at the 1-year anniversary. And that can be done either on a country-by-country basis or using the Patent Cooperation Treaty. The PCT buys us another 1.5 years after that to pick the individual countries. So that is the basic nuts and bolts of how you actually go about getting the patent. And then after the thing is filed, we have a back and forth process with the patent office where they allege that it's not patentable, and we make amendments to the scope of our claims and make arguments as to why the documents they're citing against us don't apply. And eventually we reach some sort of scope that is considered allowable. And that's basically a process that can take 3 to 5 years in the US and 5 or more years in Canada. In the meantime, you get to use the term patent pending. And you can begin to disclose your invention as soon as you've filed the application. Common pitfalls. I think this is an important slide. So one thing that often happens is people over-describe features that aren't invented yet. So they blather on and on about all these possibilities when in fact these are really future patent opportunities. And by disclosing them early, you shoot yourself in the foot for when you actually have gone about and finished the invention off and explored those features. Another thing is not enough experimental data, so we don't have an answer to the obviousness allegation. And then not being clear about what your inventive rationale is. So if we don't tell a coherent story, it's hard for us to kind of persist at the patent office in explaining why we should get a patent. If we just kind of randomly scatter a bunch of features around, then the examiner can similarly pick and choose patent documents that allegedly show those features. So we have to have a clear story of why we're inventive. So as I mentioned before, and patentability is not any guarantee of non-infringement. So a patent is not permission, it's a monopoly right. So when we are talking about whether we have the right to actually do something or not, we're not talking about getting a patent anymore. We're talking about freedom to operate, which is really based on the searches that we do and that you should be doing as well on Google Patents. So an example that helps to clarify the difference is, let's say that Jeremy has a patent for a seating apparatus comprising a seat and at least 3 legs. And that invention is called the stool. And then I come along and I see Jeremy's stool because he's filed for a patent, and I get to read the disclosure of that invention. And I think, boy, I could really improve upon that stool by putting a 4th leg on the stool and a backrest. And I file a patent for a seating apparatus comprising a seating surface supported by at least 4 legs. It's patentable, but my seating apparatus with 4 legs still has 3 legs. So although Jeremy and I both get patents, I don't have the right to practice my invention without permission from Jeremy, because my seating apparatus infringes his earlier claim. Now, similarly, after people see my chair, they may say, you know what, I don't want to buy a stool. I mean, that thing's no good at all. Like, who wants to sit on that? It's rocky, it's not stable. And Jeremy may find his business severely impacted by my better invention. And so the solution to that problem is called a cross license, where we both have something of value to horse trade, and we reach some kind of an agreement whereby both of us get to practice the invention. Or it could simply be resolved by, if the invention is, if the earlier invention and the company that owns it is big enough, they simply shut us down. They litigate us into oblivion and prevent us from our product from coming to market. So these are both a couple of potential outcomes, and we should be aware and do freedom to operate searches to make sure that we don't fall into that situation unaware. So other IP related activities that we want to be cognizant of: market exclusivity, extension through regulatory. So patents often interplay with the regulations. You're backstopped from doing something because the regulations don't permit it. And so we patent the only way to actually accomplish the function of the device while still fitting in the regulations. That's a way that we can use the regulations to extend our protection. A concept that I want you all to be aware of is this idea of due diligence readiness. So really, all of us, all of the accelerator companies are likely to see funding. When that happens, you go into due diligence with your prospective partner, and the prospective partner will ask for all kinds of documents. And so one thing that we need to be aware of and ready for is this due diligence exercise, meaning having all of those documents electronically available in a directory somewhere online, Dropbox or OneDrive, Google Drive, whatever, so that you can share them. And it's particularly our patent documents that we want to be able to share that I'm focused on, but this applies generally to all of your documents. Any contracts you sign, any employment agreements you have, any non-disclosure agreements that you've entered into, your articles of incorporation, your financial statements. We want to have all that stuff electronically ready to go for that due diligence event. And the reason that we want to be ready to go is if you have to pull all that stuff together when you're trying to close a financing, it ends up being just a nightmarish task because your time is being drawn in multiple different directions. So better to be ready with the documents ahead of time, and then financing goes more smoothly. Yeah, and then I think the rest of it is having some sense of freedom to operate as well, which we went over before. So one of the things that patents can also do for you is give you business development support. And I think by exploring the patent portfolios of competitors or also potential partners, we get an idea of what sorts of things other people are doing and what the gaps might be that could be a complementary fit between your company and another company. At a minimum, it gives us some insight into, if we map where their activity is, we get a sense of what they think the most important markets are. Now, one thing that is important to keep in mind is that everything that we see in the patent literature is published. There's an 18-month secrecy window. So patents are not published until 18 months after their filing. So everything we see is at a minimum 18 months old. So we're not going to see the latest stuff, but we're going to see what companies have been up to. So I'll give you an example. In COVID-19 right now, one of the things that's trending is all kinds of trademarks relating to COVID-19. And trademarks are published right away. Like you can search the applications right away, whereas in patents, you can't search them for 18 months. So people are looking at things like, I survived COVID-19. There's like tons and tons of stupid trademarks around COVID-19. You can see that activity trending right away, but you can't see that for patents.
So, Rob, that's actually really interesting. So, there are people who are trying to trademark things related to COVID-19 right now?
Yeah, and probably patent things too, but we won't see that for 18 months.
Right. Oh, that's really interesting.
Yeah. So that kind of concludes my presentation. I'll stop my screen share.
Okay, great.
Um, what I was thinking we could do now is just kind of get a bit of an introduction from each of the accelerator cohort companies, and then just kind of go through one at a time what their IP issues are and where they think IP fits in their business, and we'll just start having a bit of a discussion around that.
Sure. Okay, let's do that. So I'll them. I'll invite them to share their video and their audio, kind of one at a time, so we don't step on each other. So Jill, are you there?
Hi.
Hi, Jill.
Sorry, just changing this.
No
So
problem.
I'm Jill. My business is Words by Jill. I do copywriting, content marketing. I'm in the accelerator to develop digital products. So instead of people hiring me to do it, I've packaged up my processes so that they can do it themselves. And then that can hopefully scale for me to reach more people at once and sell those all online.
I think that's great. I've struggled with this problem before. Branding and describing your services and what makes your business different, particularly for a service business, is hard because it's kind of commoditized. So I've really struggled with this. So I'm well aware of what your value offering is.
So I really like doing that because I find that people, you know what it is like inside, but you don't know the words to say to describe it. So I help people, like, the clarity and the confidence is like the biggest selling point rather than me just like writing pretty words for them. So yeah, it's fun.
Yeah, and it's interesting too to take again something that's kind of a professional skill, and now what you're doing is packaging that up into a business system or business process.
Mm-hmm.
And if we kind of look at the evolution of service-based businesses, you can kind of break it down like delivery of the service is one thing. So you work as a consultant and you help a certain number of companies. But then the next stage of value is where you can actually package those services and have a package of processes and things that really kind of enable you to, let's say, replicate or franchise out your business to other people doing your service package. And at a minimum, they allow your business to scale.
Mm-hmm.
And then level 3 is where you actually go and take those software, take those processes and make them into software. And then you're able to actually sell a software product that maybe is sold to other professionals, or it may be sold to the end user if it's sufficiently distillable. And it's kind of a 3-stage evolution, and you're into stage 2, which is kind of cool.
Oh, I didn't think about creating a whole software around it.
Once you've codified your processes, the software is kind of a natural extension. It's kind of a next step.
Cool.
Yeah.
So I thought I would, I'm going to share, I have Jill's website up on my computer here, so I thought I would share that. All right, can you guys see that?
Yeah, looks great.
So I thought it'd be interesting to have a conversation about Jill's trademarks and what can be trademarked and what types of marks she could be using. So I think the first one here is this up at the top left is the words by Jill and the Jill in the script. Do you want to have any comments about that, Rob?
So trademark wise, so first thing I want to ask is, do we want to go into kind of detail with each company, or do you want to do an overview of each one first and then come back?
Let's kind of dive in deep in each company one at a time, and then we'll hopefully have time for everyone.
All right. So words by Jill by itself is a word mark. So a word mark would be all in capital letters, just no font, no tense as part of the mark. And if no one else has trademarked words by Jill, then you would be able to seek protection for that in your space. The second type of mark would be what's called a design mark for your logo. So that would take into account the visual elements. However, one caution is that the visual elements here are primarily all words. So what they'll do is come back and cite marks against you that are word marks anyway. So your design element to the script and the font, although it's protectable, it's not going to get you much farther than just the word mark. Mm-hmm. So in your case, the first thing would be the word mark. But you also have a lot of other trademark elements I could see on your site. So never stress about what to say ever again. So you could kind of look at that as a tagline, and a tagline is trademark protectable. So you could apply for protection on that. And it really comes back to what are we trying to achieve with these trademarks? And I think Words by Jill, because it's the name of your company, the name of your website, you probably want the word mark on that because it gives you this permission to use thing. So once you've actually registered the mark, it's kind of like someone has, the CIPO has, the Canadian Intellectual Property Office has said, yep, that's yours. So anybody else who's using it, well, this is, if they were using it prior, they may have some common law rights and kind of their local geography, but at least you've registered it for use across Canada. When you look at the level of, say, a tagline, you have to say, well, why am I bothering with that trademark? What is that getting me? So typically, you know, if we're looking at the asset value of a trademark in terms of enforcement, stopping other people from using your mark, the likelihood of them using your tagline is pretty low.
So I was actually thinking about it because, like, I don't have a ton of followers online, but I have nearly 3,000 on Instagram. And when I originally announced that I was doing the product shop, I was calling it the copy shop. And then just by chance, like a week later, I looked at one of the other copywriters that follows me, and she suddenly had a page up that said, the copy shop coming soon. So I changed the name of it to just like Shop Words by Jill, because I was like, that page wasn't there before.
Yeah.
So then I was looking at, okay, well, what other, or just out of curiosity, like what other things could they potentially take, right? So.
Well, and that's the thing, you can trademark all of that. So let me give you kind of an idea, because this is important learning for you because you're actually helping other people with their branding. So you can kind of convey this information to others. Mm-hmm. So I kind of look at it as almost like 3 levels. So like, and I like to use the auto companies because they're kind of ubiquitous examples. So if we think about Dodge Motor Company, okay, their top level brand is Dodge, right? And they would have the word, they would have logos, they would have stylized representations of the word Dodge, they would have all those things. One level down from that is the actual models of cars. So things like Dodge Ram. And they have, you know, the Ram trademark and the Ram with kind of a sheep's head in the middle of the logo and all of those kinds of visual branding, like different visual representations of the word Ram. And that would be limited to a class, a trademark class relating to vehicles. And then they've got taglines like Guts Glory Ram. And they would have protection for that. But I kind of view that as like level 3. But then they've also got marks for things like their parts. So Mopar is the trademark brand for parts that go into Dodge vehicles. And so there's multiple opportunities to trademark throughout that value chain. And if you're big and you're going to spend lots and lots of money on advertising, it probably makes sense to do that. You know, so taking a look at the website that Jeremy's pulled up now, we have, you know, they're not indicating these with an R in the circle. Probably that R in a circle appears somewhere on the site, because I have no doubt that these things are trademarked. But let's just see if we scroll down. Oh, just scroll up a little bit there. Right there, truck of the year with an R in the circle. So that would be Motor Trend's mark. So that's a little more than a tagline, right?
Mm-hmm.
They've indicated that that's truck of the year is their registered mark. So probably there's an agreement somewhere between Motor Trend and Dodge that they can use Motor Trend's mark, truck of the year, as part of their promotional activities. But I don't see particularly the marks listed here with an R in the circle for the Ram. I'm sure they are, but that gives you an idea of kind of hierarchy. So yes, you can trademark a ton of things, but how much money do you want to spend, and what is your end goal? Are you going to enforce these marks? Are you going to license them to others like Motor Trend has done here? You know, if you end up having a brand that has some recognition, you know, like website powered by GoDaddy, or you know, website designed by Words by Jill, these kinds of things, your mark could appear on other people's sites and could have some value as a licensing property.
Mm-hmm.
But that's all like way in the future for you. And I wouldn't be spending money on that right now, because unlike patents, trademarks get stronger with use. So the more you use the mark, the more recognition it gains. The more recognition it gains, the more it's attributed to you.
Mm-hmm.
And these tagline marks, you can just, if someone were to accuse you of infringement, well, then you just change the tagline and move on. But your actual name of your company, you'd have to change the website. That
Mm-hmm.
would be a huge expense. So I would say the first trademark you should get is Words by Jill, and then the rest of it you can think about later.
Okay.
Yeah, sorry, go ahead, Jill.
I just was curious because you'd asked about like the other things, like does the visuals have anything to do with it? Like all my custom drawn, my designer drew me like coffee cups and flower like plants and like wine glasses and stuff to go with the brand.
Can we flip back to the Words by Jill website? Any chance? So all that stuff is trademarkable. But like, why? You're on mute, yeah.
I don't know, sorry. I'm just curious about like what is possible.
Yeah, no, that's all invalid. You could trademark all of that. And if you were, you know, Dodge Motor Company, you would.
Okay.
But you're not. So I would say keep your budget tight and just go for the Words by Jill, which is the name of your website. And if that mark, if you can't get that mark, you want to know that early.
I was also told that because my script font, that's the only thing that's not custom on the site. But if I wanted to trademark my logo because it has that script font in it, I'd have to have someone create me a custom font first.
I don't know about that. I think that's not true. You can trademark with that font. The issue may be that whoever created that font has their own intellectual property rights in that font. And so what intellectual property rights might they have? So they might have trademarks on the name of the font, but you're not using the name of the font.
Okay.
They might have copyright to each of the characters in the font, in which case, and that copyright may not be assigned by use of the font for commercial purposes. It may be assigned for non-commercial purposes as part of their, or not assigned, but licensed as part of their license agreement for downloading and using the font. but not for commercial purposes. I don't know. I don't know what that's a possibility that they may require you to seek extra permission from them before being able to use their font as part of your logo or as part of your website.
Rights for like currently, like I purchased it for this reason, but there was like a disclaimer like can't trademark with this. But that was a while ago, and I let my designer handle it, so I don't know all of the details.
Yeah, I don't really know how that could be enforced, because literally your trademark is not just Jill, it's the entire visual representation. And I don't know under what circumstance they would be able to do that. Their license agreement is their only hook that they have back into you, right?
Mm-hmm.
Rob, I think that one of the interesting things that we've had come up a couple times is when people are buying logos from websites like a Fiverr, or they're going
Right.
online and finding a logo they like. So we had this problem with a team last semester where they purchased a logo from a designer who was selling them kind of en masse and very limiting, like the amount of customization to that logo was very minimal. And he found someone else using the same logo. They basically purchased the same logo and were using it for themselves. And he went back and was trying to sort out like what sort of intellectual property do I have can actually protect this logo. And it turned out I don't think he could. Do you maybe want to comment on the risks of purchasing pre-made logos?
Yeah, I remember that example you're talking about, and definitely that logo was sold to multiple companies. But as I recall the issues there, it was more relating to what they could and couldn't do with the logo. In other words, they didn't have exclusive rights to the logo. And when they went to, I think as I recall in that case, the terms of the agreement was that they weren't purchasing all the rights in the logo. They only purchased a license to the logo.
Right.
I don't think it was that they were prevented from trademarking using the logo.
Okay.
They could trademark it. So this is kind of a fundamental point, okay? So you create your own intellectual property rights, trademark or whatever. The trademark gains value by use. You're the one who's doing the use. So you're the one who has intellectual property rights in that mark. But you may not be entitled to use all the elements of the mark. That comes back to that idea of the three-legged stool, four-legged stool, although that was a patent example. But your rights to use of the logo or elements of the logo come from the terms of the license agreement. And that is copyright. So someone's created something, they have copyright in that, and they've given you the rights to use it subject to certain restrictions, subject to certain financial compensation or what have you. So I don't know that they can restrict your ability to apply for a trademark with it, but they may be able to restrict your ability to use the logo as part of your trademark. That's what I'm getting at.
Okay, that makes sense. Okay. I think we should probably move on to another team. Did you have any other comments, Rob, before we move on from Jill?
No, I think you're going to be generating IP for other people. And this whole thing about copyright comes into it again, which is that you may want to think about the terms under which you let people use certain elements of copy or whatever. Kind of hard in your business because what you're selling them is with the expectation that they're going to use it online as part of their advertising. So kind of hard to restrict Like, I find it a little dirty that someone would sell you logos and then not give you the right to actually use the logos. Like, what is that? That's kind of like a trick, right? Where they're going to come back and try and extort money out of you afterwards for using the logo that you paid them to develop for you. So I don't know how you could actually do that, but it's something for you to think about, is what actually do you sell, and maybe do you require people to give some reference to your company as in return for using the copy as part of their site. Something to think about. I think in general, people probably won't respond well to that, but if they are happy with your service, they're more likely to give you a referral, but people don't want to be forced into giving you a referral before agreeing to use your service.
Right.
I think my biggest concern is just like competitors, because like I'm giving the process to other people who aren't copywriters, but what if a copywriter comes and like takes my process and takes the logos and takes everything, right? But I haven't really thought about it that much. So
well, the bigger thing is they can take the process and rename it, right?
Yeah.
So once you're putting that out there, it's out there.
Mm-hmm.
So I think what's important to keep in mind is you're not inventing a process. You're doing a good job of describing and implementing the process and making it clear and easy to follow. And people could use those ideas and repackage them in their own words.
Mm-hmm.
If they cut and paste your words, then they've infringed on your copyright. But they likely won't cut and paste your words. They'll likely change it enough that, although the person did copy your store name, Holus Bolus, so I don't know. That was kind of weird. So I don't know if that helps, but think about what you're doing with copyright as you go forward.
Okay, thank you.
Great.
You're welcome.
So the next accelerator team that I wanted to bring up is Josh from Makabars. Josh, are you there?
Yes, I am. Can you hear me?
Can you hear you? Yeah.
Okay,
Yeah, awesome.
cool.
Josh, do you want to give Rob a quick description of Makabars?
Yeah. So Makerbars, I started it a little bit, I guess, a year ago now. We originally started as an all-in-one kit, and that was the only product we had. So it was like a meal kit for energy bars, and we would send everyone their own ingredients so that they could take a no-bake recipe and make their own bars at home. A little bit over time, we noticed some other problems in the industry that we wanted to focus on further. So one being the lack of fair trade ingredients, and the other one being just the fact that there's so many food wrappers. So with our kit, we never had food wrappers, but when we saw that there was all these food wrappers and it was a #1 polluter in Canada, we set out to see if we could make a pre-made solution that had like a compostable solution with it, some sort of sustainable wrapper around it. So we did that over the summer and we found it. And then we launched those products in August, and we have a handful of stores now and sell online. But basically our Makerbars Go is our on-the-go snack, and it's our primary selling thing right now, our primary selling product. Which allows customers to have a nice, healthy, simple ingredient protein bites. So that each pack has about 12 grams of protein to keep you full. A lot of the athletes and stuff have been enjoying it for sure. And a lot of what we're trying to do is create some sort of social impact in the fact of using this compostable technology that we found from a company in Hamilton. So I just got that packaging in about 2 weeks ago now, and we sent it out for shelf life studies. But for the most part, we're focused now on selling online here in London and across Ontario.
So you have a unique recipe for the bars?
Yeah, so we make everything from scratch to finish.
All right. And how did you arrive at that recipe?
Well, I just personally have loved cooking forever. So I kind of just was starting to put the ingredients together, looking at competitor bars as well. So you just look at their ingredient labels, and I mean, me with enough cooking knowledge can look at something and pretty much tell you how much of each thing's in it based on the order of the ingredients that are on there, especially if it's just a real food, simple ingredient bar. Um, and that's something we've never worked with, like a food scientist or something that's a formalized process to develop a recipe.
All right. And is there anything special about the bars themselves? I mean, you mentioned organic and fair trade, so that's more of a source of supply issue.
Yeah.
Anything about taste, trials that you had to do to solve problems in the recipe to make the desired consistency, any unique ingredient that isn't normally available on the market?
So not yet, but I think where we're hoping to get to is the compostable packaging. So as far as we know, we're like the first ones that are using it for bars specifically. I know that our packaging company, and I found two companies in the world, one being the one we partnered with, that have the technology. They've used it for other solutions, which are more like powders and a lot drier goods. So we're kind of taking this risk of using this packaging, um, which we haven't really seen anyone else, which then one side of it is figuring out, does it work scaled up in large machinery? And the other side is to figure out, does it give the right freshness over time and shelf life, which we're testing.
All right. And this company in Hamilton, under what terms are you using their product? Are you just a customer buying product, or do you have some sort of agreement with them?
Yeah, for now we could only get it to be just a straight purchase, but the talk of getting exclusivity with them has been brought up before. And they were saying that anything's a possibility given the right volume. So
All right. So you have no agreement.
no.
And this packaging seems like it's a fairly important feature of distinction for you, or you're going to make it into an important feature.
Yeah.
So there's a number of issues that are popping up for me. So the first issue is doesn't sound like there's anything particularly patentable about your recipe. If as you go forward, I think as you're making changes to the recipe and so on, things you would be looking for are unique ingredients or unique process steps that are used to enhance or incorporate those ingredients. For example, the addition of honey makes the product too sticky, and therefore we bake the product at a certain temperature in order to reduce the stickiness and make it handleable. I mean, that's probably not patentable, what I just said, but things like that in the recipe could be a source of future patents. And you would support those with data. So whatever problem you're trying to fix, you need kind of controlled experiments that show properties of that product before the change, and then also as a result of the change. So I'm just going to park that because it sounds like it's future IP. The packaging that you're using, you're going to put a lot of effort into marketing and using that packaging. And right now, you're exposed because you have no long-term supply agreement with this company in Hamilton. So two things can happen. One, well, more than two things, but at least two things. they go out of business. So your source of supply on the packaging is gone. Two, they get bought by somebody else who then says, you know what, these small time clients in Ontario, we're going to get rid of these because we're moving the manufacturing to the States and we're going to focus on much bigger companies, and we don't have time for your small account. Three, they could make a change in their ingredient formulation that destroys important property that you're relying on for your product, but you get kind of lost in the shuffle because you're a small account to them. And four, you're developing potentially your own intellectual property on how to use this packaging for your product and application. And in the end, you could be in that three-legged stool situation where you've got a patent on something, but they've got earlier rights relating to the product. So I think the number one step would be to conduct a thorough patent search, and maybe even ask the question, depending on how good your relationship is with them. Are they a big company or a small company?
Well, from what I understand, like they used to be called something else, and then they changed their name because they were focused on the compostable packaging now. So they wanted to change it to a more brand around that. And I wouldn't say they're massive, but it seems like they've been researching it for a while, and I haven't gotten the foothold on whether they came up with the technology yet or not. But I don't think they're massive, but I think just being a pouches and bags company, there's probably about 10, 15 employees there that I noticed when I went and visited.
Okay, so you may be able to ask them directly. I would do my own searches first, and because it can get their back up if you start asking about that stuff. But do some searches and some investigation on the background, the history, and who their customers are, and that kind of thing. So that'll give you an indication as well as to size and what other agreements they may have entered into. If they're a supplier to Lay's potato chips, for example, or something like that, those kind of bigger companies may have some exclusivity. All that being said, I think you're likely to come up with some intellectual property as part of this packaging trial that you're doing. So you're using the packaging, you're looking at freshness, you're looking at moisture and its effect on the packaging. You're looking at a bunch of different things in a systematic, kind of controlled way.
Mm-hmm. Yeah.
And who is doing that work, you or employees or contract?
We contracted that to a lab, which is really reputable.
So who's actually making the packaging? Who has the packaging machine?
Our packaging supplier.
Which is different than the Hamilton company or the same?
Same, yeah.
Okay, so they're doing really two functions. They're supplying the material as well as making the actual packages.
Yeah.
And who is doing so they're making the packages and putting your product in it.
We put our product in it, actually.
You put your product in it, okay.
So they come to us as stock and we manufacture and then seal them.
You manufacture and then seal, and then you're doing the tests on freshness and moisture content and
we're paying for the test, but we're not conducting them. So we contracted that to a company in Guelph, which is really reputable for food testing.
And they are the ones who designed the protocol for the experiments and so on?
Yeah.
And what does your contract with them say about intellectual property rights ownership?
I'd have to look at that.
That's critical. So if it's not specified in the contract, chances are they own it. And you may want to revisit that and make sure, perhaps it's possible to add that term to the contract if they don't care. Conversely, they may now ask you for more money if you're asking them for something, for a change. But I think you want to make sure that's specified in the contract and that you own. So I excluded this slide from my slide deck, but in the first instance, I mentioned that an invention is, first of all, a patent converts an intangible idea into property. So who owns the original idea is the one whose head it came out of. That's the inventor. But the inventor, once this thing becomes a piece of property in the form of a patent application, can now assign their rights, their ownership of the invention to someone else. And so because you've hired this company from Guelph to come up with the experimental design and conduct the experiments and analyze the results, most likely they are going to be inventors. But and in fact, it's even one level more, the employees of that company, the individuals, are likely to be the inventors. Under the terms of their employment contract, and this is a question to be asked, do your employees have the obligation to assign their inventions to their employer? So any decent company, and all of you listening should make sure that your employment contracts have this clause, that any invention that you create in the course of your employment is the property of the employer. Under that clause of the employment contract, now a company in Guelph owns the invention. And now under the terms of your contract with the company, you can obligate the company to assign the invention to you. And that's what you want, is an intellectual property ownership clause that requires them to assign any inventions or improvements in the product to you. So not just inventions, but any know-how, intellectual property, designs, drawings, blah, 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 blah. There's kind of standard language that we use, covers everything. But you want that clause there, because if it's not there, if it's silent, then there's no obligation for them to give it to you. You're paying them for their service, not for their intellectual property rights that they generate. And so what they can then do is come back to you afterwards and say, no, if you want the IP, you have to pay for that IP. You're saying, well, no, I paid you to do the experiments, like I paid you already. And they're going to say, well, yeah, but that wasn't part of what we charged you for. So you want to clarify IP ownership in contracts like that with third parties from the get-go. Because there likely will be some either changes to your product formulation, or changes to the packaging formulation, or changes to the process of making the packaging and putting stuff inside of it that optimizes these variables. And that is an invention.
Yeah.
So here's the other piece. I mentioned there were a number of issues. So now you have an invention. Let's assume you get all this contract stuff worked out. You do these experiments, you pay this company in Guelph to do them, they make an invention, they assign it to you, now you have an invention. But your invention requires Hamilton Company's compostable packaging. And you're exposed to them because of all these things that I mentioned about they could get bought out or go out of business or whatever. So, and then in the end, you're sole sourced, right? So you have, because your packaging requires that company, you've now sole sourced your packaging supplier. So they can charge you whatever they want because you don't have any agreement to get their packaging elsewhere. So it's really critical to understand what their IP protection clauses are. Are there other people making this compostable packaging that would serve as a second source of supply for you? In which case, you don't really want an exclusive agreement with the Hamilton Company. Conversely, if they have patents and they own some unique chemistry relating to this packaging, you do want some kind of agreement with them that obligates them to supply you for a period of time at predetermined pricing. Because that way, if they get bought, the person who buys them has to honor the terms of that deal. If you don't have that exclusive supplier, now it ties your hands, right? Because you've done an exclusive supply agreement that says you're going to commit to a volume typically. And so you say, yeah, I'm going to buy X amount, and in exchange for that commitment, you're going to give me exclusive not exclusive rights in your application, but you're going to name them your exclusive supplier, and you're going to commit to that volume, and they're going to commit to supply it to you for a period of time. That's different. If you wanted to take that one level more and say, I want to be the exclusive customer for compostable packaging in energy bars, and you're not going to sell your compostable packaging in energy bars to anyone else, that's kind of a two-way thing now. And that's a much bigger ask, because you're a small company. And if I were them, I would say, well, why would we choose you? And maybe you have an answer to that. But that's the kind of agreement we're talking about. Either, at a minimum, they make a commitment to supply you the product, or better yet, you come up with a mutual commitment that you're the exclusive customer for the product and they're not going to supply it to anyone else. So the first option, non-exclusively supply for a period of 5 years, likely in exchange for price and volume commitments. Or option 2 is exclusively supply for a period of 5 years, meaning, I don't know what's going on there. Meaning that that you've gone and gotten a commitment from them, and in return you're likely going to market the crap out of it, and that's how they're going to see growth in your market share means growth in their market share. I think that's everything that I wanted to bring up.
Great.
Great.
Oh, sorry, you still there, Josh?
Yeah, I'm just saying thank you.
Oh, no problem. No, one other thing I wanted to bring up, Josh, you've applied for trademarks already, haven't you?
Yeah, so I did for my name, Maker Bars,
That's good.
because we just noticed that like it's a pretty unique name, and we've seen other people get burned by that before. So for the $250 to apply, we understood like it would kind of start securing the process. That's all we've applied for, those, the name Maker Bars.
So when did you do that?
Last summer in July.
Early July or late July?
I think it was later July.
Because you said $250. So that leads me to believe that it was earlier in July,
Okay.
because the fees went up after July 19th to $330.
Okay.
If
Maybe it was
it's
right on the
earlier
cusp.
in July, that's actually a really good thing. You got in just before. So there were significant changes that came into place afterwards.
It was actually in June. I'm just looking it up now.
There you go. Yeah. So that's good. So you got in early. That's good. So there's a number of things that could work in your favor. But the main thing is that that you're now able to, and just so you know, Trademarks office is horrifically backed up. Like we're looking at minimum 18 months, closer to 2 years before we're hearing anything back from them in terms of examination, which is really long time. Like typically we would expect 6 months. So so anyways, you won't hear anything probably this year from them, and it'll be next year before you hear anything. And when that happens, there could be objections and things that need to be dealt with. Most definitely, you will have to agree to a classification. So you, when you filed, did not have to classify your mark. Now you do. So it's really important to look at the class suggested by the examiner and see what classes your competitors are in, because you want to make sure you get that class just right. So the suggested class is 30. That's not for sure yet. So you have the ability to flex around that, change that class. And you might want to do that depending on where it fits.
Yeah, Rob, I'm not sure if you can see on my screen here that I think I've shared with you guys. This is some details about Josh's trademark application.
Yep.
So it looks like he's class 30 there.
Yep.
Yeah.
So great job. Good thing you did that.
Thanks. Yeah, I was just worried. I heard a horror story once about a cookie company, and their name got taken from them, and then they had to rebrand launching into the US.
Yeah, and of course, this is a Canadian trademark, not a US one, right? So
Yeah.
you would have to redo the process all over again in the US. But I wouldn't worry about that until you actually have sales in the US.
Mm-hmm.
You might do some trademark searches just to be sure that it's clear. But I wouldn't spend money that you don't have to spend until you need to.
Now, just before we move on from Josh, maybe a couple of comments about, so Josh has this logo that is the M with maker bars in it. And then I was just looking at some of his products, and Josh, I think you were mentioning that some of these marks you're using on your packaging will change. But there's this mark for maker bars Go, and you have marks on your packaging as well. And it looks like you're using the M with is it text around it, or is it just dots? Independently.
Yeah,
Okay, that's text. So there's that M mark, and then there's also the M with the dots or text,
those
and
are
then
dots,
maker bars
yeah.
as well.
So dots versus text, I would prefer to see you use a consistent. So marks get stronger from use, and how companies kind of water down or dilute their mark is by not having strict policies on how the mark is used. One of the things that I've seen in the past with companies I've been involved with is things like email signatures. As you get more employees, people are using the mark in different ways on their email signatures, sometimes template, like letterhead template in an email message, if you know what I mean, like some emails that are like HTML emails. People just go off and do whatever they think looks good, and they end up not having a consistent brand presentation, and that can actually negatively impact the strength of the mark in the future. So I think I would pick words or dots. You can use both, but it just means you've got 3 marks instead of 2. And arguably, there's a 4th mark, which is M in a circle with maker bars underneath. That whole thing in the upper left corner is a mark. So you've got maker bars, the words. You've got M in a circle with dots. You've got M in a circle with words. And you've got M in a circle with dots with the word maker bars underneath. So you're replicating your mark kind of into 4. And you could apply for trademark protection on all 4. Nothing's stopping you from that. But you're just amplifying your cost. And, like I said to Jill, you can file for all these things, but what is your overall brand strategy? And so one strategy you may have.
Uh-oh. Did we lose Rob?
I think it's muted.
There we go. Thanks,
Okay.
Joe.
I don't know what happened there. I just whether that was on my end or what could have been. So what I was saying is one brand strategy you may have is to drop the word maker bars and just go with M. So kind of like Apple. Originally it was Apple with the apple with a bite out of it. And then at some stage, they just dropped the word Apple and just used the logo. And everybody knows what the apple with the bite out of it is because it's so strong. Or another one would be the Nike swoosh. They put their swoosh on all sorts of things, or Under Armour. You know, I don't know if Under Armour, I think Under Armour still says Under Armour underneath of their little H-like logo that they have. But at some stage, you may drop the word Maker Bars altogether. So I would kind of think about that in terms of your next trademark application. It probably should be a logo application relating to the M, and try and get, you know, some trademark rights around that, some use for a prolonged period of time.
And one other quick thing before we go, Rob, it looks like, Josh, it looks like you're using Go. So here you can see there's Maker Bars, which is the stylized font, and then there's the word Go. Rob, do you have any comments about, it looks like that may be a fifth mark.
Yeah, that's right. So
Go is the name of Josh's product.
Yeah, so like I was saying with Dodge, so Maker Bars is the top level mark. It's the company name. And then Go is like RAM. It's a product line, and you may have multiple product lines. And so you can protect each of those. It's all a question of your budget. The word mark Go, obviously there would be tons of things called Go, or even called GO, you know, like the acronym GO, or the word go as in the verb. So I think you'd need to search that and see what else it's been used on. And see, like it could overlap. Let's say there's an energy drink. I suspect that would overlap in class with your use. And so someone else that's not a direct competitor could have a mark in your class. And so I think you should do some searches around that word Go, and see if people are in your class.
Okay, awesome. Thanks, Rob.
Welcome.
Okay, so we'll move on to, I'll stop sharing that screen there. Reza, are you there?
Yes, I am here. Sorry, I just
there we go.
trying to click.
You're just muted. Awesome. So Reza, your company is called Spectral Devices. Do you want to give Rob a quick description of your technology?
Yeah, for sure. Hi, Rob. So our company is Spectral Devices. We make the multi-spectral cameras. It's basically such as your cell phone camera that actually takes the pictures and takes the pictures through different colors. Our camera pictures in the more than 3 colors. So it could be visible and invisible, basically color ranges. So you have a different type of cameras. You have cameras that takes from 4 bands to 16 bands, and we call them snapshot multispectral camera. And these cameras actually has a wide variety of applications, and that they can be used for the agriculture and food sorting and biomedical imaging. And I've been because I've done my postdocs at Western and also doing my PhD. Before I had 2 patents that actually we got for different technology, and for the company we also filed 2 new patent applications that is about the manufacturing of the process of these multispectral, let's say, filters that goes onto the sensor of the camera that makes the camera a multispectral camera. And so some of the technologies that we did patent was that basically how to manufacture these filters. We came up with a new ideas how to manufacture them, and we manufacture, basically we file a patent on the method of manufacturing these filters. And it's just in the process of the examination through the US Patent Office, and we're going with that right now. And one of the challenges that I realized myself, basically was that what's a patent search, because we go through these patent search ourselves mostly and see that basically there's not many technologies out there that actually similar to what we are filing and the claims that we are putting in. But there is still that basically when they come back to us and say, oh, there's some, the technology is novel, but as you said, there's something that actually non-obvious things. So maybe it was a little bit hard for us to actually differentiate between the non-obvious from the basically the from the obvious from non-obvious. That's what I realized myself. And the patent search was pretty much, it's very time-consuming job, because you have to go at least from 100 patents or papers or something like that. And we want to do the much more thorough job in future, so we make sure that the things that we are filing really, it's not basically patented or basically published before.
So there are 2 patents that relate to the technology.
That's right.
And who owns those patents?
So these patents are assigned to our company, Spectral Devices.
Okay, so you have assignments. They're not licensed from the university.
No, they're not.
Okay, that's good. And one of the patents is a method of manufacturing.
Both of them are method of manufacturing. One of them also on the device. Basically, one of them is a device and method of manufacturing, and the other one is method of manufacturing. But having said that, those 2 patents, they don't directly relate to the way that we are doing manufacturing right now. This kind of novel sort of manufacturing method that we are doing in those patents, but we are not using them at the moment, really.
So last week, I did a full day IP workshop with a company like yours, at your stage, let's say, that was spun out of Waterloo University. And we could get into a lot of things that on this, and it's going to go beyond the amount of time, but I'm going to try and ask you some questions that probably you haven't been asked about. So what is your business model? Is it to make devices and sell devices for use in food industry, or is it to actually conduct analysis of the output of these devices as a service for people in the food industry?
So basically, our cameras, when we started this company in 2015, and what we actually came up first, we came up to sell these cameras to the research community, just make this type of cameras and sell it to the different type of research institutes, universities, and R&D part of the industries. And then over the past basically year, we started working using this camera for specific application in food, and that's where we started. And we're in the process of developing basically making a product, basically a prototype, and basically doing the testing and make sure that it's working. So we started basically first of all was mostly for the research, and research was used, but right now we start to use it for more application specific, let's say in a food and agriculture actually.
Okay, so getting back to your business model, how are you planning to make money?
So we are right now basically we're making revenue out of our selling our cameras. So that's how we support these projects right now. And we have the cameras, we have systems, which is combined of the multiple cameras. And we are selling these cameras all across the world, but let's say US, Canada, Asia, and Europe mostly. And that's how we actually make money
Right.
from selling these cameras. But the project that we are doing for food right now is something way bigger than we're doing before. So it's basically a complete system solution for food inspection. So that's basically bigger than the these cameras that we are doing. So it's complete system. It's just not the camera.
So your food inspection system will involve presumably some software that's doing some analysis on the output of these cameras.
Yeah, that's right. Yeah.
So would you sell the software, or would you perform the software as a service?
Well, it has to come. It has to be a complete package. So it comes with the software, it comes with the camera, and it comes with the lightings and housing, everything. So we don't sell it separately, really. No.
And it has to be a complete package because they need instantaneous results running on a local machine somewhere.
Exactly. Yeah.
Okay, so I'm actually really intrigued by the idea of the software side of this business, because where I think you, in the long term, generate real value is by having a requirement in the software that it uploads data back to your servers, and that over time you develop a database that can be used for AI purposes. And you can start to develop improved algorithms that are based on the camera results, because you have access to that data. And so why would someone want to install a piece of software that uploads the data? I think there's a regulatory benefit. So if your software can, by taking that data, guarantee or provide an independent third-party verification of compliance for CFIA, that they're complying with the relevant regulations, that becomes a valuable service that you can offer. And so what it also allows you to do is get a longer term hook into each customer, so that there's an ongoing monthly or annual licensing fee involved in continuing to maintain this database of regulatory results. And so dovetailing your inspection cameras and your systems into what the regulatory results say is really, really important. If you do all of that, the next thing I want to talk about is patents around that, because now what you have is potentially an application of the base technology. So like I described before about the basic principle behind the patent system, it's a monopoly in exchange for disclosure. So you've disclosed these cameras, you've sold these cameras, you've disclosed how to make these cameras. Anybody else could pick up one of your cameras for research purposes and do this application. So ideally what you want to do is protect that application to prevent yourself from being locked out of it. So I'll give you an example. I once did a patent for a recyclable rubber compound. That recyclable rubber compound, they never did any patents around the recycling process or products made from the recycled rubber compound. They just patented the compound. The company's competitors patented recycling processes, products made from the recycled material, specific blends of recycled to virgin material, et cetera, and basically built a fence all the way around the actual chemistry. So what they created was a situation where they forced the other company into a cross license. So either you give me a license to make the recyclable rubber compound and we both get to sell, and in exchange I give you licenses to all the application patents and we both can make money. Otherwise none of us makes money, because I can't do the applications without you, and you can't sell your product to anybody else except me. So you do have an application, an important application patent coming out of this. And that probably is going to relate to combinations of hardware and software. So getting into software patentability, which is where I think we were going to go with Jin Moon later, is the idea of can the software itself be patented? Well, it's very complex. I didn't get into it during the slide deck because it can be very complex and case-by-case basis. But in general, software is, in the first instance, considered to be an algorithm and therefore not patentable. That being said, certain types of software are considered patentable inventions because they're methods of doing things. So if your software involves a hardware component and it's something like process control or something that's producing a physical result of some kind, then it's a patentable sort of software. And so in this case, your software would probably be cast as a process control software for a food inspection system. And it would be, utilizing certain inputs from hardware, doing certain math, spectral analysis, and then based on a comparison, generating a result relating to food inspection. And so we could probably make this software patent eligible by putting it as part of a control system for a piece of equipment. But there could be another element, which is more of an AI element, and this relates to the software. The machine is a data acquisition source. Data is uploaded to the cloud, analysis is done in the cloud, and some kind of result is downloaded back to the machine. Now that piece of software could be something you develop later. So remember in my presentation, I talked about not over disclosing before the invention is ready. This is the kind of thing where you'd want to stage your disclosure so that if you do end up developing a cloud-based solution, but you've kind of vaguely described it today, but you didn't actually have it working and you didn't actually know what was important about it, you end up probably destroying your chance of filing a second patent application for that in the future because you've over disclosed it too early. So I would hold back on that later side of the application because I think that's where the real value of this is. It's more so in regulatory compliance and third-party verification, and it's where you generate a long-term asset, which is all of this database of spectral imaging results that only you own. So that's kind of where, that's just a few thoughts that I have. Around the manufacturing, ultimately in the long run, your business is pivoting away from being a camera manufacturer to a systems provider. And you'll probably end up needing a manufacturing partner to build these cameras. So really the manufacturing patent is kind of for you to control friends, as I mentioned in my earlier part of the presentation. This is really protection from friends to prevent them from going off and selling your cameras into other applications that you don't control. Or if they do sell it into other applications, you get a royalty for that. Employment agreements. So I don't know how many employees this company has. Is it just you or is it others?
Oh, we're two actually in this company.
So you should have, if you're drawing a salary and you're an employee or not, you should just have an agreement that any inventions you come up with are owned by the company. And that's really, to protect the company. But as I was saying about due diligence, eventually you're going to have to raise money. And so one of the things people are going to look for is what's to prevent Reza from just disappearing and going and starting a competing company because he wasn't required to assign any of these inventions. And then I guess the final thing I wanted to bring up is you have application patents, you have hardware patents. It sounds like there's a device patent here, but there may be elements of this inspection system, mechanical elements, independently of the software that are also patentable. And so your food inspection system sounds like hardware plus software, and there could be patentability in both parts of it. If you're needing to hire mechanical engineers or fabricators or whatever, you need contracts with those people. Just like I was saying about the contracts with the Guelph testing lab for the maker bars, you need in your contracts with partners clear ownership of IP that's generated. And ultimately, this probably is a business that either operates as a food inspection business, or it could be two businesses is what I'm getting at. There could be a camera and analysis business, and there could be a food inspection business. And I guess just a more of an engineering point, you're at the stage now where you're developing basically custom engineered systems for applications. But you should try and think as much as possible about what are the key application variables and how do you design modular systems that can scale up readily. So, do we have camera modules and we install multiple modules? Do we have one processing unit that connects in a network to multiple systems? I'm not sure how the scale up makes sense, but whatever the key variables are, figure out how to scale it, because if you're going to sell these systems, one of the first things you need to do is have you need to have a cost model. You basically need some configurator, some spreadsheet or something that allows you to readily quote jobs. And the only way you can readily quote jobs is by understanding the scale up parameters. What are the big knobs that need to be turned to drive the cost and size of a system? And the sooner you can understand that and modularize them, the quicker you'll get a handle on your cost and be able to quote jobs. That's a lot that I unpacked into 20 minutes, but like I said, I did a whole day session with another company on this same kind of stuff. So you can get a lot out of this.
Thank you very much. I appreciate it.
You're welcome.
Great. Awesome. Well, thanks, Rob. And Reza, if you have anything you want to follow up with, I'll share Rob's contact information at the end. So we wanted to, Jin had a couple questions. Jin, are you there?
Yeah, do you hear me?
Hey, Jin.
Okay. Yeah, I'm a little dark here, I guess.
No problem.
Okay. So I just have a quick question first. Is a trade name the same as a trademark? Because I have a trade name for engine with a J.
Yeah, it's the same thing. Yeah.
All right. So yeah, I was able to get that quickly. Like you said, 6 months, but I was able to get that like within a week or so. So I was wondering.
So what did you? Maybe we're not talking about the same thing. So what did you do? Register a business name?
Yeah. So my legal business name is Money Geek Inc. But then I wanted to use Engine as an alternate name for the company. Well, so I have a consulting company that creates software for investment managers, and so I created a new brand, and I wanted to trademark that brand. So I registered it as a trade name.
Okay, so where did you go about registering that then?
I talked to my lawyer, and they did it for me. So we had to search a name and everything just to make sure it didn't conflict with any other names.
So you probably registered this as an alternate name for the business then, right? So doing business as?
Yeah, so the technical name is trade name, I believe. I read the document, that's what it said. I was just wondering if that's the same as a trademark. It sounds like it's not.
No, not if you got it that fast. So I'm not exactly sure what was done, but a trademark would be filed with the Canadian Intellectual Property Office, CIPO, and gives you an asset owned by the business as opposed to an alternate name for the business.
Mm-hmm.
You could not, if engine is an alternate name for the business. You can't sell it or license rights in it or anything like that because it's part of the business, right? So
Okay. Yeah. So it's not the same thing then. I mean, it does allow me to operate under it, but it's not the same thing as a trademark. Okay.
yeah, it sounds like slightly different. Yeah. So your software is AI based for financial managers.
Yeah, that's right. So we're creating a platform that can create different machine learning investment algorithms. Let's say you want to create a machine learning algorithm that tries to like make money in up and down, both up and down markets but just in Canada. Then the platform can create an algorithm that does that. If it wants to say only focus on technology companies, it can do that. And they would all be machine learning investment algorithms that take into account dozens or even hundreds of different investment signals and combine them into one investment strategy. So that's the concept. And I guess the other question I had was, you said that software was not, in general, not patentable. And it also sounded like scientific discoveries are also not patentable. But I do know of instances where there are new mathematical models that go into some of these, like other people's machine learning models, and they're patented. So would I be able, if we came up with a novel numerical algorithm that improves investment results in some way, would we be able to patent that?
Yeah, I looked your company up before this, and I knew this would be a topic. And you're in a complex area. So I'm going to address one of the things you said. So people with different machine learning models or algorithms have gotten patents for that. That's true. And so the basis of a software patent like that is the physical result is to improve speed and efficiency of processing of the computer. So if you invent new code in the area of machine learning and your machine learning algorithm is more efficient and thereby saves energy and saves computing resources, then that's potentially patentable subject matter.
So unfortunately, that wouldn't apply to our code. And we don't create code necessarily because it runs faster. We create code because it would produce different investment signals. Say one algorithm says we should buy Apple. Well, maybe my algorithm would say, no, don't buy Apple. Buy, I don't know, WestJet instead.
Yes. Yeah. And so I mentioned that in order for software to be patentable, it has to produce a patentable result, which is typically a physical result. So a commercial result is not considered a patentable result. Mm-hmm. So, or a patent eligible result. So if the result we point at is making money, then that's not considered a result. That being said, people say, well, I know of lots of patents on, different kind of financial softwares. And so it would come back to trying to analyze that your software will produce that result more quickly and save energy, or more efficiently saving computer resources, or perhaps it produces a better result by identifying the key variables in the machine learning data set. So let me give you an example. We patented an irrigation system using machine learning for a greenhouse. And this irrigation system used, there's a whole bunch of variables: sunlight, relative humidity, stage of growth of the plants, ambient temperature, all of which will impact the drying rate of the soil and the requirement for water of the plants. So applying machine learning to that data set of 20 variables and getting an irrigation result would likely not have been patentable, although because it was a controller for a physical process and there were physical things being switched on and off, pumps and valves and different things, we could have probably gotten something just around that as a control algorithm. But what made it patentable as software was that we took the 20 variables, did some analysis, identified that were 3 variables that were the key variables or the driving variables, did a first stage of analysis with machine learning, looking at just those variables to see whether further analysis was required or not. So like a stage 1, stage 2 analysis, which improved the speed and efficiency of processing of the algorithm, and thereby improve the result of the algorithm. So a similar sort of concept could apply with financial data, where we identify key variables. And where I want to go with this too is this idea of obviousness again. Now, and it's complex for me to explain in a short period of time, because what I'm talking about is whether your software is patent eligible subject matter, not whether it's obvious or not. But perversely, in the United States, the idea of whether the advancement that you've made is more than what is routine in the art plays into patent eligibility. And the assessment of what is routine in the art is this idea of, is it obvious to do it or not? And so the idea of obviousness plays in to patent eligibility. And
so is the linkage between physical processes and patentability only in Canada, or is it also in the States?
I'm talking more about what's in the States than in Canada, actually.
Okay. Yeah.
Because for software, the US is the more relevant market. And this idea of more or less than what is routine and known in the art is a US concept.
Because I know someone who has, say, 2 patents in the blockchain sphere.
Yeah.
And blockchain is, as just purely software as it gets.
Yep. And like I said, initially, the basic principle is software is not patentable. And then we look at these modifying concepts. And that's what I'm trying to, and it's a very nuanced thing, and it's very case by case. But in your case, we would be looking at something more like, so if I was to say what is routine in the art, applying machine learning to a data set is routine.
Mm-hmm.
Identifying how to optimize the machine learning algorithm, making a better algorithm, would be non-routine. Identifying the training data set and the key variables that drive the system dynamics would be non-routine. And why is it non-routine? Because you don't know the answer before you do the work.
Mm-hmm.
So that's where I was going with experiments. So if we can sit around the table and come up with some idea, by definition, it's obvious, because it's within the common general knowledge of a person skilled in the art. It's routine. There's nothing inventive about it if we can come up with it without doing any work. So the inventiveness actually comes from the doing of work. The inventiveness comes from the experiments. The inventiveness comes from the failure. We've tried and we failed, and we tried and we failed. And so a lot of times when I said that often one of the pitfalls is that people don't provide sufficient data, they think that they can get a patent for something before they've done any work. And the more work you do, typically the more patentable it is. The more negative results you have, the more patentable it is, because you've shown this was actually really hard to make it work. it didn't work all these ways that we tried. And until we found this magic trick, whatever it is, that's when it worked, and that's what makes it patentable. So like in your case, it would be something specific about things you've done in the algorithm to make the algorithm work more quickly or at all in this very configurable way, as opposed to relying on a brute force way. At least off the top of my head, that's what I would see as the potential patentability here.
Okay, thank you. And I guess one unrelated question. So I do consulting work for other companies. Oftentimes we sign up an agreement and everything. Everything's tight legally. In one case, though, a current client is a bank, a Canadian bank, and we didn't actually agree on an extensive agreement that spells out who owns the IP. So we created some mathematical models to address some of their needs. Does that mean that we technically still have the IP?
Yes. If you didn't assign it away, then you own it.
Okay.
I mean, that's a very, obviously I haven't seen the agreement. I can't give you a concrete, definitive statement, but the short answer is yes. If you didn't assign it away, then it must still be yours.
Yeah, I mean, all it did was, all we agreed on was a statement of work that spelled out exactly what they wanted, but there was no language anywhere that we agreed on that said who owned the IP.
Yeah, and so I'm oversimplifying things. So there's a case called Techform versus Voida, which is kind of a definitive case on ownership of inventions by contractors. And there are 7 criteria that are assessed and so on and so forth. But the main principle is that if you didn't assign it by contract, likely you're still going to own it. So you could, if you wanted to follow that up, that would be a separate contract review.
Yeah, I don't want to damage the relationship, but it's good to know.
Well, it is, and it may not be patentable if it's a purely numerical or mathematical thing anyway. But it's something to go through with your lawyer.
Yeah, I'm thinking more about, say, applying for a shred, or something. So, yeah. All right. Thank you.
You're welcome.
Awesome. No, we've come almost to the end of our time, but I wanted to see if is Brett there? Brett, are you still on the call?
Yes, I am.
Hey, Brett. So I wanted to make sure you got a quick second in case you had any questions. Brett, do you want to describe your tech to Rob really quick?
Yeah. Hey, Rob. So my company is called Heed, and we are an AI platform that recommends cannabis products and educates users. So we're essentially a personal bud tender, and we partner up with retailers, producers, and brands in order to help find them users and then give them back data to help them make better decisions. So our tech is essentially natural language processing. So it's the way the platform works is you can have a conversation, you can basically ask it whatever. There's about 15,000 models trained on it, and you will end up finding a product that works best for you. So it learns more about you over time, and all that kind of stuff. So I was always curious about IP. I actually had a meeting with an IP lawyer about 8 months ago, and it was kind of confusing. I didn't really get a straight answer. It just seemed very expensive, and the possibility of it even working was not always there. So I'm not sure if I would fit in under any categories.
Yeah, I'm not surprised it was confusing, because it is software patentability is confusing, and it's hard for us to give generalizations. It's always on a specifics basis.
Right.
Are you writing unique code?
Yes.
Or are you using other people's natural language processing?
So yes, we use Google's NLP, but but everything else is written in house. So the
And
NLP is basically is not ours.
and so on what data source is the software using to make these recommendations?
So it uses a data set that we've formulated from a whole bunch of different APIs and from different data sets. So it's basically formed from 5 public data sets, and those would be company data such as from Leafly, another company would be called Lift & Co. So yeah, it's public data that we've formulated into a data set.
So you've got public data, and the relationships between those data sets, are they 5 distinct data sets, or have the 5 been compiled into one?
Yeah, they've been compiled into one. I mean, we have 2 main data sets, so all of them are formulated into those 2.
And you have identified kind of the way to link those data sets up.
Yeah. In order to match anything, yeah.
And so does that provide training data to the algorithm, or does the algorithm refer to that data in order to make a recommendation?
So yeah, it would definitely refer to the data.
Okay.
It wouldn't necessarily learn from it.
So the AI aspect is more in the natural language processing than in the making a recommendation aspect.
Correct. Yeah. Because right now, any machine learning algorithm that we're set to create, we're not really at that stage right now. Our recommendations are based on matching from the data set. So yeah, the AI is in the NLP right now.
So let me just make a hypothesis. So if I were to describe and have a conversation with you, a human, with natural language processing in your brain, and then you went to the data set, did a lookup on the data set, and made a recommendation. Is that a fair approximation of what the software does, or does it do something?
Exactly. Yeah.
So based on that, I'm going to say the patentability is likely not there, because of what I just described to you. If what your software is doing is automating a manual process, and nothing more than that, then it's likely not patentable.
Right. Okay.
So automation is not patentability. And so, like I explained to Jin earlier, it's got to have either some aspect of improving speed and efficiency of processing of the computer, something more than what is routine, something that produces a physical result. These are all kind of indicators that we look for. But I'm not seeing any of those indicators here. Okay. So I think the likely answer is that it's probably not at this stage patentable.
Right.
You may advance that in the future, and it becomes more patentable later. I don't know.
Right. And for trademarks, that's still open then.
Yep.
But you said, what's the time frame you said on that?
There really isn't one. Trademarks get stronger based on use. However, I would say for any company that's, you know, a big part of your business is going to be your brand. I think you want to know if you can use that brand, and so I would encourage you to file. You know, heed is an English language word, so
Not really used though for past like 50 years, but it definitely could be used.
yeah, like I guess I'm saying it could be out there,
Yeah.
and the class could overlap. And off the top of my head, I can't even think of what class something like this would go into, because it's probably it's a software class. The fact that it has to do with cannabis is, I mean, it could go into either. It could go either way, but it's probably more of a software classification. So somebody else used heed in conjunction with their software, you know, and so things like take heed, or that kind of thing. Those sorts of expressions, if used in a software class, could conflict. So I think I would be inclined to file a trademark application and try and get some clearance around the mark before you get too far down the path of marketing under that name. And my solution for all of you, if basically you can't get the mark, generally speaking, the cheapest and easiest thing to do is switch names. Go to something else, because to try and, you know, pay somebody else and license it and all of that, it can take you down a path that distracts you and spends a lot of your limited capital in the startup of your business. So in case you haven't caught the theme, I'm I want people to do as much as they can for themselves and save their money and focus it where it needs to be. And I wouldn't spend much effort on patents at this stage. And with the background description I've given you, maybe you've got a sense of when you could revisit that concept.
Okay. Yeah, that's great. Thank you.
You're welcome.
Awesome. Well, thanks, Rob, for your time. I'm just going to share Rob's contact information up here. If anyone has any questions for Rob following this call, feel free to get in contact with him. I know we're hoping to have some time for questions from our entrepreneurship community, but we've kind of run out of time here. So I want to thank everyone for joining our call. I hope you all learned something about intellectual property and how it can apply to your business. I know there was one very specific question from someone in our community. Rob, I don't know if you have a little bit of time to answer the question, if we maybe break it out into a separate breakout room.
Sure.
Okay. Let me see about doing that. But thanks everyone for joining the call today. This channel will remain open for a few more minutes, but I don't think we will be here for the next little while. So thanks again for joining, and we'll talk to you soon.
Perfect. Thank you.
Thank you so much.
Thank you.
Bye. Have a good day.
Bye-bye.
Thank you. Bye.
Okay.
You may wish to turn the recording off, Jeremy.
Oh yeah, I'll do that. I'm just going to assign you and Pavel to a breakout room.
Okay. So I see I can join.
Yeah.